I'm not usually the driver on these things, so throw something at me if I do something wrong.
Okay, go ahead.
I will call to order the meeting of the Zoning and Planning Board of Appeals. First item of business, roll call. Our chair is Noel Halverson, he's excused today. Stephen Schuchart.
Present.
Brian Ritter.
Present.
And I'm Josh Cook, Vice Chair, chairing this evening's meeting. First item, or next item on the agenda is for approval of the agenda. I would entertain a motion to approve.
I motion to approve.
And I'll second.
A motion and a second. Any further discussion? All in favor?
Aye.
Aye.
Aye. All opposed? The agenda is approved. Next, we've got approval of the minutes from the March 25th, 2026 meeting. I would entertain that motion to approve.
I do a motion.
And I second.
We have a motion, a second. Any further discussion? Hearing none. All in favor?
Aye.
Aye. March minutes are approved. Moving into our regular business, first I will note that the Zoning and Planning Board of Appeals hears and acts on appeals for variances from city zoning code requirements, and as applies this evening, we are also considering appeals for issues arising under the massage ordinance. The members of the board are appointed, and the board acts as a quasi-judicial body during these appeals, which means that these appeals are presented like a case is presented in court, and the board acts as the judge and determines whether to grant the appeal by majority vote. For each item, we will hear from the applicant and staff, as well as any additional witnesses where appropriate. If you are the applicant for an item on this evening's agenda, please come take a seat at the table when your item is called. For Appeal 26-11, consideration with possible action on an appeal filed by Moonlight Spa by its owner, King Lu Moonlight, following a non-renewal decision by the Common Council for massage purposes. So if you
We're waiting for our lawyer to show up. He's running late with traffic coming from Milwaukee. We should be here shortly, within 15, 20 minutes.
I motion to move us on to the next item until...
Thank you.
Very good.
Yeah, I'll second that motion.
We have a motion and a second to
Table.
table the issue and revise the agenda. All in favor of that motion?
Aye.
Aye.
Aye. All right, moving on then, Appeal 26-05, consideration with possible action on a variance request from Carol Fleming, applicant and property owner, requesting approval to extend front yard setback standards in an R1 low-density residential district at 1317 Spence Street. This is Alder Ritterbusch, District 9. If you're here for that item, please come on up. And as you're doing so, I will note that it is the goal of the Board of Appeals to provide and conduct a hearing that is fair in form, appearance, and substance. To ensure that this hearing satisfies these goals, each member of the Board of Appeals please confirm the following for this appeal by stating I confirm. Number one, I do not have a conflict of interest in this matter.
I confirm.
I confirm.
I confirm. Number two, I have not received any communications from any person or party about this matter.
I confirm.
I confirm.
I confirm. As I mentioned first, we will first hear from staff on this matter. Please state your name and address for the record.
John Leroy, 100 North Jefferson.
And do you swear or affirm that the testimony you are about to give will be the truth?
I do. Okay, so board, what we're looking at here is variance relief that is sought for one section of the code, section 44-554. Table 44-2, note C, lot dimension and setback requirements. So for the front yard setback, it is established by the average of front yards on a block face. This block face is bounded by Roscoe and 9th. The average front yard setback of the existing homes is 33 feet. The applicant seeks to add an approximate 112 square foot attached front porch, which exceeds approximately 9.7 feet past the established front yard setback of the home itself. So what you're seeing here, along Spence, you have Ninth to the north, you have Roscoe to the south. This is a two-parcel block, and the applicant is seeking to essentially keep this front porch that was placed onto the front of the property back in the summer of last year. So with that, and adding in front porches, they cannot exceed past the established front yard setback of a block. We just have the two. In this situation, this house already, that is existing, is already in front of the house that is over on Ninth, as that one does face off towards Ninth, but the side yard itself, the corner side, is set back deeper than the house here along Spence. So during the course of routine inspections along Spence Street back in summer of last year, inspection staff had noticed that there was an uncovered new front porch here, pretty evident to see as you're going down the street with the untreated wood in this area. So what happened at that point, staff notified the applicant and the contractor who went out and built this 117-foot square foot patio, that they had done that without a permit and had exceeded front yard setback limitations on the property itself. So another photo here would show just how this porch is in reference back to the block itself. So what happened was, after the construction, a contractor had come forth and requested to put in a front porch and gave this basic application for the overall application that shows some dimensions as far as some back stairs, and then this porch out front being 138 inches wide by 116 inches deep with some stairs. So for patios and landings, it's expected that, we've seen this in the past with this board, that zoning interpretation calls for up to 25 square feet for a landing. As many homes have to be built up past the foundation, there has to be some sort of entryway into a building. But in this case, that exceeds that 25 square foot limitation, and that thus becomes a front porch on the front of the property, and thus an extension of the home itself. With that in mind, for alternatives which were brought up with the property owner, the way to make this whole would be to put in a landing that would be 25 square feet at the most. That would be an entrance into the home. Or, as an alternate possibility, the code does allow for covered front porches in a conditional use permit setting, to where if there were a covered extension of the roof that were then put forward with plans and then brought forward to the Plan Commission, possibility that that could be then reviewed by the Plan Commission and Common Council for approval, but that's in the case of only covered front porches. That's typically happening in more of the pre-World War II neighborhoods, where front porches and covered front porches at that, were much more prevalent in the architectural style of that area. I do want to note, so with inspection staff and this limited application that was put forth, even if this board were to find that the characteristics were made for an appeal on this front porch must be disassembled and put back together because it did not meet any of the qualifications of the building inspection folks. They need to ensure that what's being put forth with the proper construction materials has to happen. And there were no pre-inspections or proper documentation for this to ensure that this construction met building code provisions. So in any event, this will have to come down from a building code perspective and then reassembled in subsequent form, either through, say, a normal 25-foot or less landing, or if this were to be improved with the structure itself as well.
Thank you. Any questions for staff? Hearing none, we will move on to the applicant. Before we do, please state, and are you the applicant?
No,
You got the applicant by phone, correct?
I can, yeah,
Uh,
right, that's what I mean.
Yes, please.
Yeah.
Yep.
Hello.
Hi, is this Carol?
Yes, it is.
Hi, Carol, this is Josh Cook. I'm the chair of the Zoning and Planning Board of Appeals this evening. Before we get started on your appeal, we do need to swear you in. Could you please state your name and address for our record?
Carol Fleming, 1317 Spence Street, Green Bay, Wisconsin, 54304.
And do you swear or affirm that the testimony you're about to give will be the truth?
Yes.
Thank you. What would you like us to hear, Carol?
I really don't know. I just that I wanted a different porch put on to be safe because the other porch, the boards were starting to rot out. I fell through one of them, and I didn't want the mailman to get hurt. And these guys that were doing my lawn said that they asked if I would like it done, and I said, sure, if you can do it. And they said, yeah. So I just took them as the word. I never thought about a permit or anything. I thought they would take care of that. And it is what it is. They put this porch on, and it's not up to code.
Anything else you'd like us to know, Carol?
Well, they left all their tools here. They're in the garage yet. I asked the guys that are doing my lawn what I should do with them, and he just put his hands up and goes, I don't know. He says he doesn't even know where they are. He thinks they're out of state. So, I don't know what to do.
Well, some of my fellow board members may have some additional follow-up questions here for you.
Okay.
Okay, Carol, was it your original intention to just put up a porch that was similar to the older porch, or you
Right.
wanted a larger one?
Right. No, I didn't want a large, I wanted the same size porch.
But you did want it entry level out,
And-
where the steps came down.
And before we take additional comments from you, we just need to have you sworn in. If
Oh,
you could,
sure.
State your name and address for our record, please.
Teresa Shaw, 2613 Greenbrier.
And do you swear or affirm that the testimony you're going to provide will be the truth?
Yes.
Thank you. Oh, I'm sorry, what was this?
So it was just, she wanted the same porch, but instead of it being a step down from the house, because she uses a cane, she wanted it to be entry level out and then the stairs further out.
And size-wise, what is the comparison of this porch to what was there before?
Carol, width-wise, it's about the same, but they ended up extending it further out away from the house.
Right.
Good questions.
I don't have it.
Well,
I would like to go back to staff. if we could.
I would be happy to reopen the floor for staff.
John, there's no problem with her having that level to the front door?
Level does not matter.
Okay. And we don't have any idea what her porch looked like before?
I am bringing that up for you right now.
Okay.
Here's a street view of the parcel from back in 2016.
And that,
Did that used to be covered?
Can I speak?
Yeah. Yes.
At one time, it had like a pergola over it, not actually fully covered. But that was only for a short time. That was taken down and it was just the porch.
I think it's just an optical illusion.
Sure, it kind of looked like it was covered for a minute.
No, not really.
and, I mean, this is guessing, but that looks roughly code?
Right, we're not considering what was there before, I have no records of.
Right, yeah,
there being
that's
units.
fine, but I mean,
But roughly-
visually, that looks pretty standard to me.
Anything else before we begin deliberating? Thank you, gentlemen. What are your thoughts on this one?
With sympathy for the applicant, I don't see any way to move forward and appeal this, and approve this. It's not, you know, it's, you know, looking at the preservation of intent, and we're largely talking about the size of the porch and then also what sticks out too far. There's nothing exceptional about the circumstance, or about property rights. I suppose detriment could be argued. I don't know if sticking that far out, but considering the house already sticks out, I don't know that that's a huge deal. But, I'm not seeing a way through it. I don't know, gentlemen, do you have opinions?
Yeah, I don't disagree. I mean, our standard is if we can't reach all 5 factors, we can't approve. And I might be able to get there on one of these, but I can't get there on at least 3 or 4 of them. I feel for the applicant. It sounds like she may have perhaps been swindled to some extent here, but that's unfortunately not something that we have a lot of power over.
Yeah, no, I just echo what you guys say. I agree. Hate seeing cases like this, but yeah.
Yeah, I do too.
At the risk of calling an uncomfortable point, do we have a motion?
Yeah. I motion to deny the appeal as written.
We have a motion, do we have a second?
I'll second.
Any further discussion? Hearing none, all in favor?
Aye.
Aye. Opposed? I'm sorry, ma'am, the request was denied. You'll have to speak with city staff to figure out what steps to go to from here.
Okay, she'll have to go through.
Yep.
Yeah. Okay,
Sounds like we may have lost Carol here. but-
probably, yeah.
Yeah, I heard it.
So she's speaking with the inspector in the past. She'll speak with that inspector again here.
She did speak
Yes.
with one already? Okay.
Yes, yeah.
Okay.
So I think he will reach back out again to her to let her know there was the denial, and they'll take up the next step.
They'll reach out to her, or I need to have her?
She,
reach out?
either way, but if she wants to
Okay.
have it resolved tomorrow, or some resolution tomorrow, she can call in. Otherwise, when they have their next convenience. we
So
can
is
call back.
somebody gonna be driving by daily charging her?
Not yet, no.
Okay. Because if she tears it off, there's nothing.
Understood, yes.
Okay.
Yeah. We'll work with her on this.
Okay, I'll let her know. Thanks.
Thank you.
Thank you.
Do we have counsel here on the Moonlight matter?
Yes.
All right, I will recall Appeal 26-11, consideration with possible action on an appeal filed by Moonlight Spa by its owner, King Lou Moonlight, following a non-renewal decision by the Common Council for massage purposes, and I do apologize if I butchered anybody's name.
Don't worry about it. Where will we sit?
Right up.
Yep.
right up.
Before we start.
Yep. Before, sorry, anything outside of the agenda, council?
I'd just like to update the board on some of the parameters and how we should move forward with this before we hear from both parties. I'd like to educate the board a little bit on the process, if that's, if I could have that opportunity.
No, that was much appreciated by the board, or at least by this board member.
Yes.
Well, I'm not going to try to do that. Chinky, why don't you sit?
So if you don't mind, then I'll just kind of educate a little bit on the process here. Oh, please, feel free to take a seat.
Oh, I appreciate it. Thank you. I was just wondering, she doesn't speak much English. She translates for me, so I want to kind of put her in between.
Okay.
Go ahead, sir.
So we're here part of a stipulated agreement. There's a little background here. On July 15th of last year, the massage establishment ordinance had a renewal process, and the petitioners went through that renewal process and were non-renewed, and which resulted in a circuit court action, resulting in a final stipulated agreement to have this board hear this matter and make a determination. In between that, the ordinances have changed, and I believe the parties have agreed to understanding that the ordinances, as they stand today, would preside. So I wanted to kind of take you through what that process looks like. So an application will come in, and staff members review the application for completeness. And there's generally three categories that they're looking for. They're looking for, did they complete the application? Did inspections approve this? And did PD approve it for their background check? So in that process, what that would look like is, like a denial is an option, or it gets approved, right? So that's one of the two options here. So we'll go through the denial and what the regulations are here. And ultimately, what the board is looking to determine here is to decide whether the city's determination to not renew the massage establishment license for Moonlight Spa shall be upheld, or if the application shall be granted. And so I can take you through what the regulations are, and then what the criteria staff looks at, and then ultimately you'll hear from both parties, and then it'll go back to the board to make that determination again to either uphold the city's decision or to grant the application. And if you have questions along, just please let me know. I'm more than happy to jump in. But you know, this is the quasi judicial. We'll go through the same process here. You'll swear them in for testimony. You'll hear from staff, and then you'll hear from the applicant or petitioner. And for something like this, I would recommend potentially a time limit on how long we want to spend for each party to have. 5 minutes sounds appropriate to me, but again, the board can certainly make that determination. They can always ask more questions as they see fit. So that's what I have to present to you. And we certainly can go through some of the slides too if you'd like to see what you're actually looking at. Would you like me to take you through some of that?
I don't think, speaking for myself, I don't think we have any idea what we're looking at, because this is our
Sure.
first go-around with this particular one.
So the first thing we'll take a look at is that massage establishments are subject to regulations. And so, you know, I believe that the petitioner did have a license at one point, so they were subject to these licenses. And these are the regulations here.
Steve, I've got those.
So
those
that's
issues printed off
fine, I
as
can
well.
just read it from here, my eyes hurt today, so
Mhm.
I gotta look closer. Here's a.
Oh, I just wanted to give you a chance to read. I
Yeah.
know sometimes it's helpful just to be able to read.
And I gotta tell you, there's no way I can read that from here. Is there any way we get a thank you, sir.
I can't,
It's a copy of the ordinance.
I'm sorry, yeah, I just copied off the
Fine.
ordinance.
It's fine. It's a copy of the ordinance, so.
I got you. Thank you.
Forgive the highlighting.
Done.
That's fine.
Thank you.
And so you'll hear from both parties as to their positions, and then ultimately at the end, they'll go back to the board to determine whether the city's decision shall be upheld or whether the application should be granted.
What's the standard for that?
Standard for, like the reasonableness standard?
The standard for upholding the, is this a
Yeah.
rebuttable presumption? Are there preferences we're to give? What is the standard for us to uphold?
There is no, because it's municipal and because it's an ordinance like this, it's just a general presumption standard. So the city just has to prove that they had a basis, a rational basis for their determination.
Is there any precedent for this at all?
Say it again?
Is there any precedent? Has this been done outside this board at all?
This is the first time that this board has heard.
Right,
this
I
type-
get this board, but assuming that there's been massage parlors here for, what, a decade now?
Have
Has there been
other boards heard this type of appeal previously?
Who's
Yes.
handled the appeals in the past?
So that would have been council, the common council. And so there's a different process now, so I can break that down briefly here. So applications come in and staff makes determinations.
Right.
And so if the staff makes an adverse determination to an applicant, their recourse for that application is to this board. Now, if their application gets approved and they're operating, if there's a revocation to suspension, that's a common council process. So it's bifurcated there so that the party that's seeing the application is not also ruling against the license if it's been approved. So there's some separation of vows there, so they're
Okay,
different.
so staff reads it over
Mhm.
and then denies it or approves,
Correct,
and then if they want to contest the result, they come to us.
yes.
But didn't I read in this that this common council already made?
Yep,
that
and so
determination?
that's where-
That's because it's already, it was already approved once and the
Okay,
council
all right.
revoked, and that's why we're here.
Yep.
Okay, and if I'm reading it right, also that this is the final stop because the circuit court motion was dismissed with prejudice?
I don't know that it was dismissed with
What it said
prejudice.
on-
There was
what
a
it said on the
stipulated agreement
document.
that this body would hear and make that decision.
Okay.
Yes.
Now, so it's clear, it's my understanding it was dismissed with prejudice, but there would be nothing that would prevent us from refiling another writ if it goes against us.
Anything that happens, correct me if I'm wrong, anything that happens from following this board's decision would follow the same type of process afterwards that any other zoning variance.
And I would generally agree with that. The only thing that's different here is that there's a stipulated agreement. So I'd have to take a look at that stipulation agreement again, just to determine what the next steps are. But for here today, we're just here to determine, the board is going to hear this determination. That's outside of this board's determination right now, but,
And so what you're telling us is that there's no, so normally for the ordinances that we do, we have I believe it's state of Wisconsin, and maybe it's just Green Bay, but we have a section of 5, conditions that we have to fulfill. You're telling me in this particular case, we have no conditions to fulfill.
the condition you have to fulfill is to determine whether or not the city staff had enough evidence or basis to make the determination. And so like, there are a number of different determinations. So like where zoning board has to meet those 5 criteria, there's a finite number of, the situations are all different, but
Right,
they
right.
all result back to zoning and what does the ordinance say. And that's a similar situation here, is that it'll go back to what does the ordinance say and what does it require. And so walking through the, the regulations and then also the basis for a denial. The
So
base,
that's really the question, where the basis is for denial.
yep, we can go ahead to that slide if you'd like to take a look at that slide.
Yeah, please.
John. So it's a little small, I can read all out if you'd like,
No,
or you
it's
can
fine.
take a
I
look.
can just move on. Section B is a criminal statute,
That is true, yes.
so it's not, it doesn't count against municipal findings.
It can include municipal offenses that are similar, yes.
Does it say that somewhere?
If
It
it's
does,
back into
yeah,
that
yep.
sentence, yes.
Yeah. And I think it's important here to remember too how this got here. So this started with a non-renewal, which that process does not exist anymore under this ordinance. And so you have to consider relevant factors, including but not limited to those that are listed under A through D.
So subsection A would fold in all of the menu items that you had on the board earlier, correct?
Correct.
And so our standard isn't whether it's a good idea or a bad idea to vote, it's whether
There's a basis.
there's some basis under that menu of options.
Yeah, yes, yeah.
And our determination of that would be under section B, then, right? That they have been, that there has been that there have been fines issued or a citation issued.
I think we're under A and B.
Right, right.
So if you want to relate it back to zoning, I think an analogous example would be that it would be as if John would have to prove to you that the ordinance existed and that they followed that ordinance. Whereas the zoning board goes a step further to determine if there's a balancing test of, is it fair or not to the applicant for that adverse decision the city made. Here, just determining whether or not the city had a basis for it. And if there is a basis, then you uphold, and if there is no basis, then you would grant the application for license.
And then, one other procedural question I had is, as I read through the ordinance, there's a bunch of language in there about whether to accept written or oral testimony, whether to go into closed session.
Yep.
Are any of those circumstances present here now? I haven't heard anything significant enough to require that.
Yeah, I don't think so in this situation. Again, this resulted from a stipulated agreement, so in the future, there may be closed session language, but I don't believe that we had closed session language for today. Double check that real quick.
The reason I ask is I think that one of the reasons to go into closed session has to do with potential issues of litigation, which I know is somewhere in the background.
Yeah, let me take a look at the agenda real quick. I'm sorry, let me pull it up in front of me. Okay, thank you. Okay, there's not. So today we wouldn't go into closed session.
Okay. All right, just trying to make sure I...
No, and I think that part of that was, the stipulated agreement, these parties agreed that they were going to hear it.
So basically what you're saying is we're here to determine whether or not, according to this, they don't meet the criteria.
Can you say that again?
So we're here to determine whether or not they met the criteria and the city ignored it, or?
What do you mean by they? They
The
okay.
applicant.
Okay, yes. I would kind of reframe it, whether or not the city made a determination.
Right.
And so that to determine whether or not whether there was a basis to have that determination. So it's not so much whether the applicant completed their part of it, it's really to determine whether the city had a basis to non-renew their license.
If I'm understanding, did the city meet one of the factors under A or B, and A has that list of 10 or 12 different items?
Correct.
Is there somewhere under those 12 or 13 pieces that was the reason for the non-renewal?
That's correct, yes, yes. Is
That's
that,
an extremely broad set of categories. The way you're defining it, when you say
we'll hear
basis.
arguments in a minute, but I'm just presenting to the board for now, but we'll have an opportunity for arguments.
But you're guiding the board as to how they're supposed to make a decision today. So I do think it's a valid argument to talk about.
You can make that argument when your time is appropriate.
So what are we doing right now? You're telling the board.
We're educating the board.
You're educating the board.
Yes, thank you.
According to how you look
Thank
at the
you.
law.
Yes, thank you.
Is this how we're going to?
Thank you, sir. Thank you.
And to be very clear, we're not taking testimony right now. This is an education piece
Yes.
that is a regular part of our board's operations. We haven't even begun testimony, nor have we sworn anyone to take testimony. Do you have any other questions from the board on this issue?
Council, tell me why I shouldn't withdraw and make this not a quorum, so that we don't have to do this. This does not make me comfortable. We were not educated beforehand, we were educated in front of council, and then which was also probably not appropriate. I'm not comfortable that we can come to a determination because there's no procedure, I'm not a lawyer, he is, but we're not. And this is a far cry from determining zoning. And there doesn't seem to be, like, for instance, you can't live in Green Bay and not read about X or Y bar getting their liquor license removed, right? But there's always a backstory behind that, and I'm certain they're willing to tell us all of that. And I've read the documents, I actually read all of this before I came here. There is not, I'm having a really hard time understanding what we're supposed to do here.
Yeah, you're supposed to determine if the city has met the criteria to deny the license.
Right.
Yep.
What are they supposed to argue against then?
They mean I'll leave them to have that argument for why they believe the city may have made an adverse decision to them. I think you could hear that testimony, and I think you can weigh the balance of those two and determine whether or not.
And what if it comes down to, because one of the things that were submitted in evidence to this was the citations that were given.
Correct.
But if they want to argue about those,
I think you can certainly hear the testimony for that.
And
I
without,
think what I'm not doing is giving rationale to any of the evidence that's out there right now.
Right,
I haven't heard that
I
yet, but
understand
you're able to
that.
hear that, and you're able to ask those questions directly with the council here. I do think that this board is capable of hearing the testimony and listening to the evidence, much like you hear from John, and to make a decision. And I understand that it is different than zoning.
my concerns are not as much for me as they are in the interest of fairness. And to me, fairness requires a full understanding.
and if I can lend my 2 cents, I think that's largely the job of the applicant and the staff here is to give us that education, just like John does in the context of the variance request. I think these folks need to testify
Okay.
and educate us.
I will be led by you in this. Okay, thank you.
Good, all right. Do we want to go into the quasi judicial hearing?
Unless Brian has any questions?
Nope.
I would then move into the item here. I don't even recall at this point if we've confirmed we don't have any
No,
conflicts.
Haven't done anything.
Uh,
So start right at the top.
Thank you. It is, again, the goal of the Board of Appeals to provide and conduct a hearing that is fair in form, appearance, and substance. To ensure that this hearing satisfies those goals, each member of the Board of Appeals, please confirm the following for this appeal by stating, I confirm. Number one, I do not have a conflict of interest in this matter.
I confirm.
I confirm.
I confirm. Number two, I have not received any communication from any person or party about this matter.
I confirm.
I confirm.
I confirm. And to the extent that we have an interpreter involved here, who's doing the interpreting? I'm sorry.
She's not really doing the interpreting, she's just communicating with me to her. So I don't know if we have an official interpreter. It's my ability to speak to my client, that's what I'm using it for.
Fair enough, that we won't swear in an interpreter because I think it's more of an informal here at this point. Then we will move into the applicant for the city. Please state your name and address for the record.
My name is Lacey Gauchard, I'm the city attorney.
And do you swear or affirm that the testimony you are about to give will be the truth?
Yes, again, I'm here representing multiple departments who have a role in massage licensing.
What can you tell us about this thing?
Sure, so we submitted largely the record in this matter. I don't have a lot of additional comments to add, but I'll take you through a bit of it. So you've heard about the massage licensing ordinance. We have, to some extent, regulated massage establishments in the past to the extent that their employees had to be licensed by the state, and you'll see a violation in your packet of that. A few years ago, we put in the ordinance in place and have since licensed these establishments on an annual basis. So the applicant here in 2021 received a citation for operating a business without having licensed massage therapists. You'll see in the packet 4 guilty pleas for municipal citations.
How were
I'm sorry, go ahead.
How were those guilty pleas? Were they no contest? Was it adjudicated trial?
I think you could certainly ask the petitioner's counsel. I think it's probably a mix of both. Failure to appear, maybe. I don't know that any of them went to a full trial. To the extent that matters, therefore guilty convictions. And as a quick side note for that, we spent the last year in this writ of petition for certiorari process where Attorney Connors was trying to reopen those citations, which was ultimately denied by Judge Chagot. So those citations to date stand, and they're the basis for the denial of a massage license. So as I mentioned, there was a citation issued in 21, a citation again issued in 24 after multiple violations were noted. And then at a period of time after that, this establishment became licensed. And then again, following licensure in 2025, another compliance check resulted in multiple violations that led to a citation. The reason for the non-renewal is just a repeated history of violations and a demonstrated inability to comply with the ordinance. And we understand in the past, and speaking with Attorney Connors, that there's been, some inability to understand and operate in compliance. But this demonstrated process is both multiple occasions for education and time before we did licensing, and then after licensing was in place, again, continued non-compliance. In multiple occasions, it's the applicant hiring individuals who are not licensed. And again, this is the extensive history, and it appears from 25 because we've been in a state of, since this non-renewal, and dealing with this certain court process, which was mutually dismissed for another hearing. Since then, Attorney Connors did also note to me recently that they were still operating, but this establishment, from the city's perspective, does not have a license to operate.
Were the 2025 citations, so were those ultimately could we find it as well?
Yes, and that information, a copy of that court record is in the packet. Again, I apologize that I can't tell you for sure on how they arrived at that, but all four, the 21, 24, and then 2 and 25 are all guilty. And they're all, I should note again, just to be more specific, they're all violations of 1095. F1, again, several of them are for employing massage therapists not licensed under Wisconsin 460. So that's 1095 F1C, other noted violations, but all four of them are violations of city ordinance 1095.
How many, I'm sorry. We're not there. Go ahead.
Anything else that we need to know? Otherwise, I will open it up to my fellow board members for questions.
Again, as I said, this was largely on the record of everything that we've submitted. I think you have all the information, including the police reports. I didn't feel it necessary to go through all of that with those individuals because the city's basis is, in fact, the convictions, and multiple convictions over a period of many years, including after licensure, just show us that the establishment can't operate in compliance with the law, and that was why we chose not to renew. I would just add that the applicant in the future with perhaps other employees or some other manager could apply for a license in the future if they could demonstrate some compliance with the law or ability to do so.
So out of that menu of 10 or 12 different pieces under this ordinance, we're only looking at the one for the violations of the ordinances, correct? That's really the basis for denial or non-renewal?
Yes, the multiple violations.
We're not looking at hours of operation or other things.
Well, the citations were issued for specific violations, and in the record, as an example, it says a massage license wasn't prominently displayed. There were other violations noted, and then one citation was issued at that time. That's the same for the more recent one, I believe in 25, 5 violations were noted, and one citation was issued. It was no employee on scene had a valid massage license. No license displayed, issue of record keeping, proof of insurance, etc. So, but again, one citation issued.
I don't want to get too far into the weeds on the attempts to reopen the municipal court citations, but what were the grounds that the municipal court judge denied those requests to reopen?
I believe just that they were already adjudicated, and I will note that our municipal prosecutor opposed the reopening of those because they were, the position was that they were properly adjudicated. But again, I would defer to Attorney Connors if he has an opinion on it as well, because I wasn't a party in that proceeding.
Just a quick question, when you say they were properly adjudicated, and this is my ignorance, who adjudicated that before the court?
Well, it's held before the Green Bay Municipal Court, and the municipal prosecutor.
Okay, so the municipal prosecutor, okay.
Prosecuted
the
those
municipal, okay.
citations.
That's what I didn't understand, thank you.
Any other questions for city staff before we move into the applicant?
I have a couple. So, how many of the convictions are for having non-licensed people?
I think 3 of them. So when there's a reference to 460, that's a reference to the section in 1095 F1C. So that was in 21, and 21 again was before we had a business license. And then in 24, again, you can still be operating this business, but your employees have always had to be licensed under the state license, and our municipal code incorporated that. And then in '25, also without a license, but a subsequent as well for other massage regulations under F. And I think if you could see in the reports in those occasions, it wasn't necessarily the owner that wasn't licensed, it was multiple different employees.
Right,
and-
right, yeah, I read
Yep.
that part, yeah.
Again, it's largely, all of this is on, all part of the record.
Yep, I see that. And then, so, enlighten me a little bit. It was said during the educational session beforehand that the ordinance had changed between the determination and now? Or did I misunderstand you, sir?
It did change, yes.
Okay.
with the state.
I think just as a point of order, I think we probably need to swear counsel in if this is a testimonial response.
Okay.
In general, just to be clear, in general, attorneys don't have to provide an oath, but if that's how you operate, that's perfectly fine. Let the board's
We like to
counsel
overcover things.
Okay. Sure. I'm sorry, Attorney Wood, I apologize for saying that. I didn't, this is the first time I've seen attorney sworn in.
Logan Wood, business address 100 North Jefferson, Green Bay.
Swear or affirm that any testimony you're about to provide will be true.
I do. So the ordinance did change in between there, yes.
Okay. And under what ordinances are we doing this?
What ordinance changed?
Yeah, well, I mean, so the ultimately the denial was done under the old ordinances?
It was a non-renewal under the old ordinance.
Ordinances.
Yep, then they were not renewed by council, and then they went to circuit court.
Right.
In the time that it was in circuit court, and before there was a stipulated agreement, the ordinance did change to allow for a bifurcated process, and so that if there was a denial of the
And
application,
then they agreed, and then everyone agreed to do the bifurcated process, is what I'm hearing. That's what the agreement says?
the agreement says that this body will hear it, which is
Okay.
consistent with the ordinance as it's written today.
That's what I was,
So,
okay. Okay.
For clarification, we reached, my office reached an agreement with Attorney Khanna's to dismiss the certiorari petition in circuit court, which again was largely on hold for a period of time, in favor of a new hearing before the Board of Appeals, because the ordinance had changed to direct these appeals to you all as opposed to council,
So
and largely because it's a quasi judicial proceeding.
Sure. The list we had up earlier also said within the last 3 years, so should we be counting in your opinion, do you think we should be counting the 2021 conviction?
Well, it's a pattern of the same violations. So again, that was before the licensing, but it was used to determine the background check at the time of issuance. And again, we're talking about a license that was issued in '24 and non-renewed in '25. So if you want to use a 3-year period, it would just be the '24 and '25, which I would say you should use your discretion on that.
Okay, thank you. Do you have any, looking for just some kind of pattern in the way the city enforces this? Has the city denied a renewal license before?
Yes, yes it has.
And do you have any testimony to give around, let's say, how many violations and of what sort those had in that determination as well?
In another instance, or in another case, well, I don't have any with me, no.
Okay.
To the extent that was important, I don't have another person's application or denial.
That's it for me. Thank you.
Thank you. Brian, any questions?
No.
All right, we will then move to the applicant.
I have a quick question. Can I answer that?
I suppose with this being a quasi judicial body, there would be some degree of cross-examination. This is a little bit new for us.
I would just note that the city did not present any witnesses other than presenting testimony, so I'm not sure if this is exactly appropriate for cross-examination of attorneys right now. You have an opportunity to present your testimony.
She did say she put a package in, and the decision in order from the Green Bay Court, I have it. I'm sure you have it. Did you include that in the package?
I don't know what document you're referring to, but I'm sure
Well,
you'd be
the
happy to
statement.
take it.
I mean, if you have anything, council, that you'd like us to see or hear on those.
What? I would love to have the Green Bay Municipal Court decision in order put into the record.
But before we do that, I will just ask that you state your name and address for the record.
Attorney Scott Connors.
And do you swear that the information you're going to, that the testimony or information you're going to give will be the truth?
I do.
Will anybody else be testifying here today?
You know, to be quite frank with you, there's been, in my mind, like a very dramatic turn in what I would call the direction that this case was originally put in as. Now, when it originally came in as a ad violation. They were ads that were placed, that were attributed to her place, adult type ads. The evidence in that would, if we would have put it in, if it would have been part of this, would have shown that the police department conducted no investigation and that the addresses on these adult ads were not her address. The phone number was the same. That was the, what I would call a very justifiable aim to weed out the so-called bad actors in the massage business. Today I come to court, and all we got, mainly because I don't think they would be able to successfully, with the stuff that we have, with the evidence we have, proceed that way. Now it's just the licensing. I was kind of surprised by that. She does have a license. She doesn't have a license for, she has a personal license. She, if we're going to testify today, if she's going to testify, she'll testify she has nothing but licensed workers there. If she testifies today, or the gentleman in the back who has basically helped her manage it, which goes along somewhat with the decision, would testify to everything that she's done to try to get her place in order and up to code and doing what she's supposed to. So yeah, I'm a little surprised by all this, to be honest with you. Oh, one other thing I want to mention. Now, this came up briefly, and I was thanked a lot for it, but I did have conversations. She mentioned the conversation that I had with her about whether she's operating or not. And that was part of, I don't know how you're recording this or if it's being recorded, but it was interesting that that came up. And then when I talked about the writ of certiorari, and you guys mentioned the dismissed with prejudice, that was specifically brought up within the conversations I had with the current witness. And then within that, there were assurances made to me that I could pursue another writ of certiorari.
And to be clear, we're not deciding any of those
No.
issues here.
Yeah, we're
No,
not.
well, just want it on the record, in case that does happen, that I would file, I'll skip that, I'll strike that, we'll worry about that later, but I had that conversation. So, anyway, that's that. As far as witnesses, I don't know if it would be easier, because we don't have a translator here to go through. She's, like I said, she's an assistant more than a translator. If I could have Mr. Dufresne testify, Brian Dufresne, who is her significant other, English speaking, who has helped her with almost every move that she's made within the department, with buying this shop, even within the original sale. He could testify as to some of the things that were going on in her life at the time. One of the things that was mentioned today was fairness. And there are extenuating circumstances here that I think that he couldn't enlighten the board on, on the body here.
I mean, counsel, it's your petition.
Well, then I would like to do that if it's possible.
Within the
I can get it done in 5 minutes.
within the realms of reasonable time, because we do have a pretty package.
I got it.
I would,
I can ask real fast questions.
Do we want to proceed with this without an interpreter?
If we're taking testimony from Moonlight, Ms. Lou herself, I would not feel comfortable moving forward, but if we're taking testimony from anyone else, then that's...
I mean, you know, these were all upheld. I mean, why didn't you bring an interpreter?
Why didn't I bring an
Because
interpreter?
you knew she couldn't speak English. That was clear through all the evidence we were given.
So I didn't bring an interpreter because Mr. Connors didn't request one, and at the last hearing, he represented his client. Well, don't roll your eyes at me. We've known about this hearing for a month.
I have
and you
never
could've- you
represented
could've
her in
submitted-
a hearing before.
You represented her at council,
It's-
and we've been working on
with
this
you,
case for over a
with you.
year.
Folks,
Yes, I'm
it
just
sa-
saying that.
It says
just
in
to the-
here that the court routinely provides translators for these kind of matters. I would assume
Yes,
that if
they
we're going to
support this.
appeal, if we were going to appeal, that the city would provide us with a translator so we can do our jobs. I'm tempted to make a motion to just kick this for next month until the city can provide a translator.
That's fine. Whatever you all decide. I'll just note that we provided a translator at council when requested on multiple occasions,
Okay.
and the city pays for that service. But
I
in
mean,
terms of
I-
documents submitted or requests made today,
Right.
you can see the document that we submitted that we've known about this hearing for
I
over a
mean,
month.
Josh, am I out of league here thinking that if the person who actually got the citations can't actually be questioned because we don't have an interpreter?
I would just note that I don't believe that we received any request for translator.
Okay,
The
if you
city
have a
can't,
request
the
about
city
it, was-
can't.
This is quasi judicial and we should have known.
We do it based on request,
And-
yes.
and
It has to be
that's-
requested.
Let's all make sure that we're not talking over each other. If
Fair enough,
there has to be- Frankly, I'm a little bit less concerned about the way that this has been presented to us is based on the guilty adjudications. And I don't want to get into deliberations here, but there's been an adjudication of guilty.
Yes.
And that's kind of what we're going
Did you read what?
I'm trying to talk and read, and I can't do both at the same time.
If I may summarize a little bit,
Sure.
she assumed there were bills in paper, and she doesn't speak English, and the judgment basically says ignorance of the law is no excuse. I'm not arguing that, that's absolutely true.
And it
But
is,
it's an interpreter-based problem, and I don't feel like I want to continue having interpretation-based problems because we don't have one to keep her from testifying. And since it's the license she's asking for, I am not comfortable proceeding without an interpreter.
I mean, knowing that, one of our goals here is to have a hearing that is fair and form and substance, I don't necessarily disagree. I don't like kicking this out, given the number of folks that are sitting here.
No, I don't either, but especially considering Attorney Joe Corley's here, but I also don't want to do this not right, and I also don't want to set a precedence that we're being held to a legal standard of having to apply when we don't know any of that. We're not lawyers, except for Josh, and he doesn't act as a lawyer in this particular circumstance.
I would just note again, the stipulation for dismissal, that is from circuit court requiring that this hearing be held today. And it also notes that the claims and causes of action by and between among the parties will be dismissed on the merits with prejudice and without cost. So the petitioner here knew that today was the day for the hearing. If we get requests, we do process them accordingly. I understand that they're bringing up that claim now. They did have an opportunity.
It's not even really the claim. I mean, the issue of not being able to speak English was part of the, even if I never received this document from him, I would still know this because I read the documents that you guys submitted to me that talked about that there were interpretation issues all the way along with the police, with everyone. It's even mentioned in the police officer's notes that there was a significant language barrier.
I mean,
Has the court ordered us to do this today? Or just add a scheduled meeting?
and my other frustration.
Schedule and hold hearing.
My other frustration, though, is perhaps some degree of sandbagging. I mean, Attorney Connors knew that his client
Yeah, no,
a language issue.
I'm not happy with anybody here, to be honest with you, but, I mean,
Briefly on that, I did not know that an interpreter was not going to be here today. I'm sorry. That is on me, but I did not know.
I mean, at this point, I don't think it matters whose fault it is. You know, from our side, we need to make sure it doesn't happen again, but on the other hand, I don't want to do this without, matter of fact, I move it to delay this until next month, you know, and so that we can have an interpreter.
I have no objection to that if that's what the Board of Appeals would like to hear, and we could certainly provide one. I'd like some clarification as to what dialect with the interpreter will be successful.
Mandarin Chinese.
But I have no objections to doing so, as I said, and I think Attorney Connors can submit any information for the record if you'd like to as well.
I'm sorry? I didn't hear that.
Any documents, your document that you provided in back, if you want to submit that to the record. Again, I don't have any objections, but it's not my decision. But I appreciate the concern.
We have a motion, we have a second.
Okay.
Then,
Then we'll proceed.
then we'll have to proceed. Motion failed. Counsel, what else do you have?
No, I-
Support of the appeal?
All I have is the testimony from Brian as to what she was going through at the time. Whether the court wants to hear it or not, or the body wants to hear it or not, is up to you, of course. It won't take long, and we'll move from there.
But it's not our decision about whether or not we hear it. If there's something that
You
you'd
want-
like us to hear,
you'd like to hear.
now's the time to have
Sure.
it heard.
But I want you to come up real fast. And I'll just do some basic foundation questions, and I'll just move to...
Yep. And sir, do you, please state your name and address for the record?
Brian Dufresne, 1740 East
And do you swear or affirm that the testimony you're about to give will be the truth?
Yes, sir.
Thank you.
Brian, how do you know Ms. Lou?
A good friend, and possibly a wife.
Okay. I'm going to ask the questions fast, I just want to get the foundation going. You're familiar with the shop that she has located on East Mason, correct?
Yes, sir.
And about how long has she had it?
5 years.
And you were instrumental in helping her try to buy that, weren't you?
Yes, from day one.
And even though you don't speak Chinese well, and you don't participate in the day in, day in and day out operation of the shop, you're familiar with how it's been working?
Yes, yes, sir.
All right. And because Ms. Lewis, I'm asking leading questions, if anybody objects, just say so, I'll take more time to do foundation. Ms. Lou is your significant other, for the most part, whatever your relationship is.
Yes,
Okay. During this time period, in this last 5 years, she's has medical issues, hasn't she?
yes, she is.
Specifically what?
She's had stage 4 cancer,
Okay.
ovarian cancer,
And at that time, were there periods of time where she could not work?
for quite a while, over a year.
Okay. And during the period of time that we're talking about, whether some of these tickets were incurred?
Yes,
Okay.
yes.
And she had other people working at the shop, did she?
Yes, she did.
Do you know anything about their backgrounds or what she had?
Not too much.
Okay. Were they Chinese?
Yes, they were.
And they spoke Mandarin Chinese, to the best of your knowledge?
Yes,
And could you communicate with them?
yes, I could.
To the point of operating day in, day out business, or to the point of asking them questions about licensing and things like that?
Pretty much through translator on the phone. All I communicate.
So during that time, was she bedridden?
Yes.
Okay. And you helped out as much as you could taking care of her at home?
While I was also working 40, 50 hours a week, yes.
Okay. So you weren't able to work in the shop per se?
No.
Okay. Is she in remission now?
Yes, she is.
Does she have any employees working for her?
She has one
And to the best of your knowledge, do you know if this person is licensed or not?
license, application, insurance, everything's on file.
Okay. That's all I have.
I would like to say one thing.
Bob? You have a question? 1 second. At the last hearing, I wasn't aware of that. I don't know if that's relevant right now. I don't have any other questions.
Any further questions from our board members?
So while the owner was ill, the people running the shop were not licensed?
They had a body massage license, is what they had, not a state license. The body massage license was through the state of Wisconsin. That's what they provided, a certificate with that.
So we're quasi-legal here, so I'm going to ask you a question directly. Can you explain the difference between those two things for us?
Me?
Yes?
No.
Okay. So let me ask a question more specifically then. During that time, did they have a license that the city of Green Bay considered to be valid under its ordinances?
I thought they did, yes.
Okay.
That's not exactly the question, not what you thought they did, but did they have a valid license?
Excuse me?
Did they have a valid license, or did you just?
Yes, they did have a valid license. They have a Wisconsin license that was provided.
No, that was the answer. That was the question I wanted to answer.
I had no other questions.
Council, I think when you first kicked things off here, I handed you.
Did I give it back?
No, I don't think I've gotten that one back.
I'll get it back.
Got a bunch of green highlighting on it, if you don't mind.
I got it. Thank you, sir.
Thank you. Any other questions from fellow board members? We'll then move into deliberations. Gentlemen, what are your thoughts?
So the question in my mind is what the city presented, is it a pattern of behavior or is it a pattern of misunderstanding? It's the question. We don't have any precedent on under what the staff of the city does in terms of how many of the times that they denied licenses, under what circumstances, how many citations that they have. Because when I look at this, okay, not having licensed people, to me, that's a problem. Not having the license prominently displayed, prominently displayed to me is a pretty squishy term, and I don't think it's a basis for that. But we do have, and the one from 21, I don't think we should take into account, because it says right in there, for the past 3 years, and if the city was taking that into account, to me, that's a mistake. Whether it shows a pattern or not, the code says within the last 3 years, and that's that. They can either have it strict or they can have it sloppy, you can't have it both ways, you know what I'm saying? Reading through the packet again, it talked a lot about, the ordinances in the city of Green Bay are designed to help the city regulate this trade, to prevent it from becoming a sex trade, and to prevent it from becoming a problem of human trafficking. If I take that into account, none of the citations are around human trafficking. It's not measured. Sex trade is not measured, or is not mentioned. I don't know. I'm trying to find a rational way to think about this and make a determination. Josh, I'd love to hear what you've got to say.
Yeah, I'm looking at this, and I think our discretion is a little bit more limited in this area than it is in our usual context of a zoning variance, which is perhaps frustrating. But, and that's why I asked the questions during, one of the reasons I asked the questions during our education session is, are we looking at whether there was anything under this menu of A through K on the regulation of licenses under the ordinance. And the answer I got was, as long as there's some connection between that menu of options and the denial, I don't know that we're looking at whether it was a good idea, a bad idea, or what the city's done on other particular licenses. Is there something here that is a rational basis for, is there a connection between this and the denial? And the first item I'm seeing there is that the licensee shall comply with all city codes.
Which, I mean, is also sufficiently broad as almost not matter.
It is, but we also have,
And if she didn't sweep her front sidewalk, we could deny her license.
but I don't know that that's for us to determine whether it's a good idea or bad idea.
I think that's exactly what we're here to determine, isn't it? Because why would you come to a quasi-judicial body if you wanted to run it by the books? I mean, we famously don't run by the books.
But that's where this, I think, is a little bit different.
I'd like a point of clarification, maybe it's amongst us, but maybe I'm unclear on what exactly we're supposed to be answering, because if it's what I originally understood, it's, does Green Bay have, a basis, a sufficient reason?
Right.
I mean, I need to know exactly what we're answering here, or I need a reminder of
Yeah,
that.
do they have a reason, and, you know, do we agree with that reason?
Okay. I think it's just, is it there? It's not, do we agree, is it right or wrong? It's, is it there?
Right.
And,
I mean, that kind of obviates the entire need to bring it in front of us, doesn't it?
Well, not necessarily. I mean, it's, is there a rational basis to, in the ordinance to deny this? And we know that there are multiple adjudicated reasons here.
Right. We have 3 reasons, and we were told at least 2 of them within the 3-year time limit for having unlicensed people. And that, to me, that's a concern.
Right.
But the ordinance is also written for any city ordinances, which is, to me, just, if we go this mechanical about it, that means that they can cite anything to deny for any reason they like.
Possibly true, but I don't know that we have anything in front of us that's showing that the city's just issuing citations willy-nilly just in front of it.
I'm willing to accept that the city's citation is valid, the court's already said so. I mean, I don't want to argue that in particular. What the question really is their interpretation of why they did, this is why I was asking about how they were doing it before, because, and this is why I asked about liquor licensing, because when you look at liquor licensing, the city generally works with the business to try and, bring them into compliance so they can keep their liquor license or get it back. And frequently you read about, these deals were made. But that's also after a long understanding of how liquor licensing works for bars in Green Bay. We don't have that benefit. And we don't know if the city tried to come to accommodation. We don't even know if, other than the court actions, if the city did anything except issue the citations and then the denial. I mean, if we run this 100% mechanically, they issue any injunction for anything, which is number 1 point on there, the city can just say, nope, we don't have to do it, and then our hands are tied. If they came, let's put it this way, if they came in here and said they denied it based on the fact that they didn't keep their sidewalk clear during a snowstorm, which is also an ordinance violation, would we accept that? Because the way you're interpreting it says yes.
But I'm also swayed by the fact that the reasons behind and I don't have the document in front of me anymore, but there were motions to reopen, the grounds to reopen a municipal court case or any cases, whether the issue was a result of mistaking, inadvertence, or excusable neglect. And so the municipal court had an opportunity to consider the reasons behind why there was it was just a payment issue, even if this wasn't something they wanted to put in a municipal court trial. There was an opportunity to see, was there a good reason why this wound up in a default judgment or a guilty disposition. And I think, we've got some degree of a corollary by looking at what the inspection staff is inspections isn't just marching on issuing civil fines and citation the first time they see an issue. So I think we have the institutional knowledge to understand that the city's not generally issuing municipal court citations or running up bills where there's not something more serious going on.
I don't know that in terms of a massage parlor or a bar, that that's necessarily true in the city of Green Bay. I'd love to assume that,
Sure.
but yes, the court did say, yes, those are valid, and it's because she paid them.
I think there were, in the brief review I had, that there were several different reasons behind
Right.
the decision. And I know paying it was one of the primary, but there were other reasons justifying the decision not to go.
Again, I don't really want to argue about whether or not I'm willing to just to say that these are valid because the court said they're valid. I don't really need to know necessarily why they did it, but when we look at the totality of it, and the city seems to want us to take a look at the totality of it, since they wanted us to go back to 2021, which is, again, you can either have it soft or hard, not both. Do we look at this and ask ourselves, was there any effort made by the city to ensure that this doesn't happen again so that she understands? Was there any, they don't have to do that. But again, with no understanding about how fair or not the city has been up to this point, with no understanding on how it's been enforced in the past, and with no experience on our end adjudicating any of this, it's difficult to look at this and just say mechanically, well, the fines are there, the city noted them, therefore it's fine. I feel like we can't just do it like that, even though I wouldn't necessarily vote against that in that particular case.
Yeah, I think that's where this one comes to us, though, is in that sense it is different from our usual workers. We are being asked to look at this more in a more closely fashion.
See, and I think the exact opposite. There's literally almost nothing that asked us to look at this from that. It didn't give us anything other than did they have sufficient reason, which is a soft standard.
I look at, when I heard the presentation, I said, was there a rational basis connecting the decision to one of these menus? And I'm looking at the first item on the menu. That there's a, that's, I don't get a whole lot of that of this one. I hear you, and I share your frustrations with this process. I don't love that this board is being asked to make these determinations. I think there are bigger picture issues at play than this, but from what we've been educated on and presented with, the question is pretty narrow. Is there a rational basis? And I tend to think there was. That's not judgment about whether there was a good reason or a bad reason or any other reason other than there was a reason.
Well, and again, that asks the question, why did you need the board for that? There's no judgment call at all on that. Like I said, they could get fined for having their front parking lot not shoveled. And we wouldn't even be able to say no. What's the point of having us do this if we don't have any room to maneuver? They issue a citation, the court says it's a valid citation, and we say, yep, that's the end.
But I think that might be, that's part of the point, is the court is determined, yeah, it's a valid citation. And it's getting to the point of the citations being issued and the court finding and upholding that decision. I think that means something.
It does, but the way you're characterizing the power of this board is to say that we don't have any.
I don't feel like we've got a lot of discretion on this particular.
And I do see your point too, and I think in the interest of time here, I think somebody should make a motion.
I've done a lot of talking here. I guess I will be the moving board member on this. I would move to uphold the city's decision to deny or to revoke the license in this for the reasons set forth by the applicant as well as the information that was provided in the public notice and for all the reasons we discussed this afternoon.
I will second that motion.
We have a motion, we have a second. Do we have any further discussion? All in favor?
Aye.
Aye. All opposed?
Nay,
Thank you.
it's a protest.
Council, you can take up any further conversations about this issue with the city attorney's office.
Yes.
Thank you.
I'm sorry, guys. I wish this could have been smoother for you.
It was different.
I imagine. Oh, I was thrilled with this. Let's go back to more exciting things like, zoning.
John, you're back on. We next have, I believe we're at appeal number 26-08. And thank you everyone for bearing with us during that.
Yeah, thank you for me being long-winded. I apologize for that. It's just, I really wanted to get it right, you know?
Our next item then is consideration with possible action on a variance request from Dalton Reach of Reach Management applicant, on behalf of JEM Properties and Investments LLC, et al., property owner requesting approval to deviate from minimum standards for an enclosed garage for a 3 to 4 family residence at 1330 Crook Street. Alderman Galvin in District 4. Before we move into the agenda item, it is the goal of the Board of Appeals to provide and conduct a hearing that is fair in form, appearance, and substance. To ensure that this hearing satisfies these goals, each member of the Board of Appeals, please confirm the following for this appeal by stating, "I confirm." Number one, I do not have a conflict of interest in this matter.
I confirm.
I confirm.
I confirm. Number two, I have not received any communication from any person or party about this matter.
I confirm.
I confirm.
I confirm. We'll first hear from staff. John, you've already stated your name and address for our record previously. Do you swear or affirm that the testimony that you are about to give will be the truth?
Yes.
Thank you.
All right, so the property that you're looking at right here is over on 1330 Crooks. It's this parcel here that happens to be a 3-unit apartments located mid-block with the parking in the back. I'm going to list off for you the actual section of the code. This is newer, so what's coming into play here, the City Council approved changes to the zoning code back in December 2nd of 2025 for affordable housing. When that occurred, there was a difference in denoting what a 3 to 4 apartment is, giving distinction that would be that different from before. And before that code update on December 2nd, essentially, if you were a 3 to 4 unit apartment, you required 1 stall per unit plus 1 additional stall. No enclosed stalls were necessary at that point. When the code update changed, the classification for 3 or 4 unit apartments were then updated to try to have these type of units located within neighborhoods act and feel more like a typical single or 2 family unit in those neighborhoods. And with that in mind, there's a garage change to this. So the code states that for 3 or 4 units, enclosed parking requirement within an R1 or R2 district, this is an R1 low density residential district. Each dwelling must include an enclosed garage space for each individual unit. Multifamily dwellings, 3 or 4 units, shall provide a minimum of 2 parking spaces enclosed. If a parcel cannot provide an individual enclosed space for each unit beyond 2 parking stalls, a dedicated storage area exception may be considered by the community and economic development director or their designee. For each unit that does not have an enclosed garage space, it must be included with a site plan. Said storage area must be a minimum of 120 square feet. For each unit, said storage area shall be tabulated as an accessory use. Said storage area can be located within the primary building or as an accessory building. In this case, the applicant is seeking to have 0 enclosed garage stalls. So what matters to this is just the timeline. So there were some inspections that were occurring with this property. As noted, this is a 3-unit apartment. The building was built back in 1898. It's considered to be a legal, non-conforming 3-unit residence. So the reason why it's legal non-conforming is before the code changes, 3-unit buildings were not allowed in R1s. Now, they can be considered a conditional use within R1 districts, but you need to meet some of the design metrics, which would include having garage stalls. So, inspection staff was having discussions about this garage here back in the property in October and November of 2025. And on November 4, 2025, a raise repair process for the existing garage was put into process by staff with orders at the garage. The address is unsafe and in a dangerous, in its current state, due to that dangerous condition, the garage had been condemned. So at that point, you have your opportunity to either raise or repair the garage itself. Mind you, on November 4th, you could take that garage down as a 3 or 4 unit legal, non-conforming use, tear it down, and this site back on November 4th had the appropriate parking. It was fine because it met the 4 stalls necessary. As you're seeing right here, 1, 2, 3, there's room for a 4th. The amount of space you need to have for a residential parking would be 8 feet. So this looks to be about somewhere around 36 feet or so. And so there's room for 4 stalls to occur back that way. And that's even without tandem parking, which, 1 and 2, you can have tandem parking as long as you don't interfere with another unit as they have ingress egress back of the building. What you're seeing in this aerial photo is that's the garage in place. And so this is the garage in question. Okay. So what the applicant would like to do is take down this garage, raise it, but not put the garage back up. Prior to the city council approving these changes on December 2nd, that was fine, you could do that. City staff spoke with the applicants and their maintenance staff, said, hey, let's get an application here by December 2nd and we can move forward with that. It did not get one in time. And so, as you can see over here, application dated on 12/17. I do believe it was actually received on 12/28. Either way, it was after that December 2nd deadline. So because new changes went into effect on December 3rd, with that in mind, 3-unit building, fine, but you need to have a garage. You keep, the point of the code is not just tear down garages and then just have to utilize existing surface space. You need to maintain then a minimum of 2-stall garage for a 3-unit building. And you can go and request to have an additional 120 feet of extra storage space, either inside the building or outside the building, and say a shed. But the code that was put in place, trying with the knowledge when discussing with members of the public during a comprehensive plan update, that a lot of times why we wanted to have that rule in place was to prevent people having outdoor storage of goods spread throughout. And typically, people use their garages not just for a car space, but for the storage of their own individual goods on site. So that's the challenge. The applicant is seeking to have 0 stalls with this site, and the code maintains the need as of December 3rd to have at least 2 plus extra storage space for a 3-unit apartment.
Can you remind me again, when are those conversations about raising the garage?
Yeah, October into November, with then one of the inspection staff being in touch here on November 4th as far as the condition of the garages, and then receive the application then in late December.
And the consequences coming down the pike were communicated around that time in some form or fashion?
Yes.
So it was a repair or tear down order?
Yeah. This is the existing garage.
Right.
As So the rest of the property, yeah, this is a zoom in as to what is there and existing on the property. If we're going back to the pre-code changes, removing the garage would have been fine as far as meeting the standards for a legal non-conforming 3 or 4 bedroom, or sorry, 3 or 4 units residential.
And the determination it was structurally unsound, it was going to fall off. That was kind of what I was getting there. It wasn't because the garage doors are ugly, or?
First line says it's unsafe.
Yeah.
I can't read.
No, that's fine.
Even with my glasses, I can't read from here. Okay. So, if someone owns in a similar situation, if somebody owns a 3-bedroom unit, the city can condemn their 2-stall garage and force them to build a 3.
Not necessarily 3, no, but would have to meet the requirements to where you'd have to have at least a 2-stall garage and 120 square feet of extra storage space, correct?
Alright.
So you can, if you have a 2-stall garage, if this was repaired, that could stay that way. That'd be okay, because you already have a legal non-conforming situation. The issue is you can't just tear it down. You're losing your non-conformity at that point.
Is it still there?
To my knowledge, yes, yeah.
Okay, I think I understand.
Any other questions? Well, then we will now hear from the applicant. Sir, please state your name and address for the record.
Dalton Rouge, 1241 Bellevue Street.
I apologize for the mispronunciation of the last name.
Yeah,
Do
that's
you-
okay.
Do you swear or affirm that the testimony you're about to give will be the truth?
Yes.
What can you tell us about this situation?
Yeah, John explained it quite well. Basically, there was a violation on the garage, like you saw. They gave us 2 options, either repair it or tear it down. And through that time of us trying to figure out, is it cost effective for us to repair it, or how do we go about repairing it? Because it wasn't necessarily just put some paint on it. I mean, there was some structural issues, and we're trying to figure all that out. Or do we tear it down, which are both not decisions you make quickly. I mean, so while we're trying to figure that out, this code change came into effect. And then through that process, you know, a week or 2 later, we ultimately decided that it's best for us to tear it down. The garage is not used. Since we've been a part of the garage, it's not been used. If you see how the parking happens, the way they turn in there, if anyone wants to park behind another car, you end up being in front of the garage, so if you park in the garage, you can't back out. So it's just never been used. So we just decided, well, it's not used, we should just remove it. It's better for our parking, or it works how it is now. It's always worked this way. So it just took us some time, again, to try to figure out, you're calling contractors, you're waiting to get bids back, you're waiting for them to get there. I don't tear properties down all the time, so even to figure out who to call on how to tear something down like that. So it just took us a little longer than, you know, we had for time to make that decision.
Did you speak to the city about options? Did you? I mean, normally you get together with John and talk about what you can do. Were any other options beyond getting an appeal and tearing it down? Any other options there?
I mean, the options we were given originally were repair or tear down.
Okay. But in light of the new ordinance, you just basically, what you're asking.
In light of the new ordinance, it's repair or replace.
Right, with one that is conforms.
Yeah. Yeah. The reason why we ended up going the route of let's just tear this thing down, remove the concrete, put grass there, was to repair it, you would have essentially built new. You would have been tearing the trusses out and just, it didn't really make sense. It was, yeah, I guess we'll just remove this thing. So So at this point, I guess what the city's asking us to do is build a new garage.
That's what I'm hearing.
Yeah.
Or storage, or, yeah.
I'll note, Stephen, so the requirement is to have at least 2 stall garage.
Right.
The reason why we didn't say if this was a 3 or 4, you need to have a 3 or 4 bedroom, is just recognize that on a lot of these lots, they're pretty narrow.
Yeah.
And you don't see 3 or 4 garage stalls on a lot of, many of these lots. So trying to still allow for the intent of the code, i.e. store things away and not have it strewn outside, that's where the additional 120 square feet come into play.
So the other question would be it's such a okay, so if he tears down that garage and he builds another one, and let's say he adds the 120 square feet at the back of it or on the side, whatever, make it look nice. Can he even put it where it was without getting another variation from us?
You know, I believe in this case, so the dimensions that you need to keep in mind would be the garage needs to be 2.5 feet off of the side property
Right.
line. And as far as having tandem stalls for folks who are parked over this way, I would suggest, no, tandem stalls wouldn't happen in that. But if we're talking about individual stalls,
I mean,
you
can he
go
just
through
put up the
angle-
garage he has again and still be in code?
The garage, so what would be required by code would be the following. You still need to have these parking stalls on this side because you need to have at least 2 garage stalls. But for all intents and purposes, you need to have a parking stall for each individual unit. So you need to have 4 parking stalls and then 2 garage stalls.
Right.
Yeah.
But where the current garage is, if you put it up in the exact footprint, does he still need a variance or no? Or do we know?
I
It's okay
do
if we
not
don't
know. I do not know for
Okay, if
certain.
we don't know, then
Yep,
it's not a
yep.
big deal, yeah. Okay.
Can I still talk or am I
Yeah.
still- Okay.
Close to the.
I don't know if that picture shows a good job of it, but where that silver car is, again, if you park there, you can't pull into the garage. Like the back end of it, especially if you have a larger SUV, is in front of the garage stall. It's, so, there's just, to have the parking spots there, we turn left into there. They blocked the garage stall, so we just never used it because it ended up just becoming parking problems with people in the garage stall, and someone parks outside of it, and then there's just a conflict there. Because like you said, it is a narrow lot, and to try to fit all that in there.
Other questions at all? Well, gentlemen, I'll take a crack at a few of these.
Please.
I'm going to skip the preservation of intent right now because that's the one that's tripping me up.
Me too.
I think I can get there on the other ones. Exceptional circumstances, I think this is a pretty exceptional circumstance. I mean, Mr. Roosh is caught in between some really bad timing. I don't disagree that even a couple of weeks notice before that zoning change went into place isn't a lot to make perhaps what was a 6-figure decision. I don't know that there's anything else that, in this neighborhood that's going to fall into this type of donut hole, for lack of a better term. I don't think this is a general or recurrent issue. So I think this is a pretty exceptional set of facts here. Preservation of property rights, I think a variance is necessary for preservation and enjoyment of property rights. It's a 3-unit building. I don't know that 2 garage stalls is going to really help much here, considering that there's still a 3rd unit that has to park.
Where it's thing, it's almost counterproductive.
And parking is still going to be challenged, even if you start parking people inside that garage, then you're going to run into problems. I don't know if there's any detriment by by allowing a variance here. And what we're doing is really continuing what was legal, legal non-conforming up until the decision back in December. And I don't think this is self-imposed or solely economic. I think this is a really weird timing issue. Right term.
And actually, that's what I would point out for the preservation of intent. And normally, I would not be able to come to any kind of preservation of intent finding for this. But in this particular case, to me, this is exactly what you said. This is a donut hole problem. This is a repeal we're going to do once, probably never again. And outside of this time frame, I'd probably vote to deny this. But in this particular case, I think I can say that it preserved the intent of the prior ordinance, because that's really when the whole issue came up, and that's kind of where I'm hanging my hat. I know that, we could point fingers of who should have acted sooner, or when, or how long things take, but I think, considering, to me, that's a relatively short time frame, like you said, and especially to decide whether to put it up, get the plans, get it submitted. I think that preservation of intent is to the prior ordinance, and whether that's a good legal way to do it, I'm not sure, but for purposes of this board and for purposes of this particular appeal, I think I can get around that personally.
I guess I would piggyback just a little further. I think the preservation of intent under the current ordinance is to try to minimize the amount of disorganized parking and overhead construction. Requiring this to be rebuilt or repaired really complicates the issue for this particular property more than it solves.
Yeah, because they still won't get these draft because of the way that's warranted. So. All right.
See, Stephen, every now and then we still get along.
Absolutely.
Brian, any further thoughts?
No, you guys convinced me.
Well, do we have a motion?
I motion to approve the variance as requested.
Do we have a motion? Do we have a second?
I'll second that.
Any further discussion? Hearing none, all in favor?
Aye.
Aye.
Aye. Thank you. Thank you, Ted. Just work with John to square the rest of this away then.
Okay.
Next, we have Appeal 26-10, consideration with possible action on a variance request from Jim Wolf of Vierbecker, applicant, and Dan Peters of Robert Peters Construction, Inc., property owner, requesting approval to deviate from corner front yard setback standards for a one-family residence within an R1 low-density residential district at 1437 Baumgart Road. This is Alderman Hinkvis's District 12. So come on up. Do we have
I'm not seeing the applicant here.
Anybody for this appeal?
We've got a lot of people on our on 2609 then, don't we? Then I guess we'll,
I move to table this till next month.
thank you. That's what I was-
I'll second that.
We have a motion to table, second. Any further discussion? Hearing none, we will, all in favor?
Aye.
Aye.
Aye. So tabled. Moving on to Appeal 26-09. Very patient people. Consideration with possible action on a variance request from Seth Comer, applicant and property owner, requesting approval to deviate from front yard setback standards for a one-family residence within an R1 low-density residential district at 1737 East Shore Circle, Alder Presley, District 6. Come on up, folks. Before we kick off, I'll remind everyone that it is the goal of the Board of Appeals to provide and conduct a hearing that is fair in form, substance, and appearance, to To ensure that this hearing satisfies these goals, each member of the Board of Appeals, please confirm the following for this appeal by stating I confirm. Number one, I do not have a conflict of interest in this matter.
I confirm.
I confirm.
I confirm. And number two, I have not received any communication from any person or party about this matter.
I confirm.
I confirm.
And I confirm. We'll hear first from the applicant. John has already stated his name and address for the record previously. John, do you swear or affirm that the testimony you're about to give will be the truth?
I do, and I just want to acknowledge that there's a member online who's raising their hand if you want to acknowledge them by chance.
Oh, I'm sorry. Who do we have online as OKA? Do we have anybody OKA? Are you raising your hand or wishing to be heard?
I see him unmuting and unmuting. I don't know.
He doesn't seem to be muted right now.
Oh, never mind.
Okay,
Different
well,
person.
Okay, Dave, if you want to type in a response here, if you'd like to say something, we could hear that, but in the meantime, we can move on with this presentation and then actually address it.
It kind of looks like OKA may be only.
Raise their hand
online as
again.
well.
They're unmuted.
We can't hear you at all.
The other person that mod appears to be speaking.
I can't hear him either.
Right.
It says mute right on,
Yes, for our chance to meet
That's
them.
first.
Okay.
Well, while tech folks continue to work through that, why don't we move into this
Yeah.
appeal?
Sounds good. We'll get into that here. So what's at play here is section 44-554, table 44-2, note B, which you've seen here earlier today, where at least 60% of the front footage of a block is built up with principal structures. The front yard setback for any new structures shall be equal to the average of the existing structures, except any structure that which may set back 20% or more or less from the average may be discounted from the formula. So along East Shore Circle and East Shore Drive, within 500 feet of this parcel, we did not go the entire extent of East Shore Drive because it is a long block, but we went 500 feet, as that is our typical block max length. The structure, existing structure is approximately 171 feet from the front right of way, and they are seeking to place an addition onto the front of the principal house that is 121 feet from the right of way itself. The average for the block is 181 feet. And you're going to see, as for principal structures along this average of the block, their parcel is this narrow parcel that happens to be right here. This is a photo from 2023. There has been more structures built in this area since then. So they are seeking to add on to their existing residence. The applicant is not seeking to add on to the rear of the property. There's a few things to note with that. One, there are code requirements for bulkhead lines and ordinary high water mark off the bay to where there has to be a setback. And you're kind of noticing that here with other properties to where they're new, to where there's a line as far as where the bulkhead line was established and remaining off of that line itself. That would go to approximately where this patio is, plus a few extra feet for any sort of expansions on the back of this property. The second thing is noted from, here's a street view of the property. You're going to see a few of the homes that happen to have accessory buildings that are placed in front of the structures. The second thing that you're going to see here with other properties, the newly built that's been built out here, is the distance that these structures are from the established bulkhead line, and the overall distance leads to where that line for development ends up being about right here, or in this case, off of their back of their existing patio, about another 10 to 15 feet or so is a max that you can go and be built. So they are seeking to place the addition of the house right here. As they note, there are some newly built structures that have occurred over here. That one went through, these two here went through variances in the past 2 years for accessory buildings. When reviewing other accessory structures that exist along East Shore Drive and East Shore Circle in this area, the setbacks for those accessory structures vary between a 54-foot setback and 126-foot setback for the front of their structures in relative terms back to East Shore right-of-way. And in this case, this expansion of the front home is seeking to be near the far end of that range, but in between at 121 feet off of the front of the East Shore right-of-way. Putting in some garage space and some additional building space on the front of the property. This meets the code as far as other structures in the area have to be two-story homes. We feel that the garage itself does not go beyond 60% of the overall front facade of the building, and it appears as though it is set back the minimum 5 feet off the side yard setback. So what's coming into play here is a request to have the front of the home go past the established average of the homes on this block.
Thank you. Any questions for John? Hearing none. We do have a couple folks for the applicant. Please state your names and addresses for the record. And are you both speaking?
We also have a couple others too.
A couple others. Well,
We'll start with ourselves.
First, all right?
Seth Colmer, 1737 East Shore Circle.
Leanne Seidel-Kumar, 1737 East Shore.
And do you each swear or affirm that the testimony you're about to give will be the truth?
Yes.
What can you tell us about this?
So we have a fairly small home. Currently, we have just under 1,000 square feet of living space with a single stall garage attached. Home was built in the 1940s. It's an old small cottage that was added on to in the 70s. What we'd like to do, we kind of just started driving this, was really the need for a second stall garage on the home, is what we'd like to do. Currently, we kind of have to park outside, and we wanted to take the opportunity to add some additional living space onto the home as well. We're kind of planning for the future as well with some of our additions of ADA accessibility, more wider doorways and things of that nature going forward. So I mean, that's really kind of the big need to go off the front of the building is, as John explained earlier, is going off the back with the two new homes that were built on either side of us. We would start impeding a lot of the water use of our neighbors. If we were to go off the back, we'd get about 20, 25 feet, I think, off the back of the house right now if we did. We'd be blocking, for sure, at least 3 or 4 windows from our neighbor to our west. Then we'd be blocking some of the western views from our neighbor to the east as well. We understand the value of having those water views, so we really don't want to do that just to add a little bit of living space for ourselves. And that doesn't really accomplish the second garage need as well. So that's the primary reason for going off the front of the home. We're staying within the setbacks of the side. We're not asking for any variance that way. We just want to come out a little bit further. It's the only way we can go. As it was explained to us as well by city staff that even to do any kind of an addition off the front is pretty minimal. We're pretty much at the extent of as far forward as we can go on our current structure to begin with. So it would severely limit our ability to do really anything with the house. We had even explored putting a second story on the home at one point. It's a current, just a CMU block foundation from the 40s and then from the 70s. Not entirely sure the structural integrity of that, if I can handle that second story load. So we prefer to just start fresh with poured concrete foundations and go forward that way.
And just maybe to add on top of the, one stall garage, that is also our basement access. So even of the one stall, you can't use a full one stall. So today, I'll be honest, our garbage cans live outside, our cars live outside. Same thing you were just talking about with your multifamilies. It's really, I'll be honest, we're the eyesore. So we're really trying to do what we can to build something within the footprint of what we have. If you'll go back and look, the lot lines are also angled. So even with the narrow lots, because of the way we're angled, there's literally nothing we can do from an outward standpoint that will actually allow that to happen. So really that's, what we tried to do is work within, obviously side yards as much as we can. Try not to impede our neighbors as much as we can. And then also try to make sure we could, get garbages inside, get our 2 cars inside, try to make our house look like all the nice brand new homes next to us.
Yeah, kind of getting up to that same aesthetic level as the homes around us.
So that's why we're asking for more.
Questions? We've got some other folks here. I will take you folks one at a time, ma'am. If you could please state your name and address for the record.
Kathy LaFave, 1731 East Shore Circle.
And do you swear or affirm that the testimony you're about to give will be the truth?
Yes.
Are you guys here testifying together or, sir?
John Kraft. John Kraft, 1751 East Shore Circle.
And do you swear or affirm that the testimony you're about to give will be the truth? And what else can you
We're
folks
each
add?
live on each side of them.
Just like now.
Yes.
Are you guys on the right side?
Especially if you're facing the
Yes.
road, it's correct.
And I just built my house new and John built his 2 years ago. Yeah, so we built new houses. John moved back further. I made sure I didn't go back too far because I didn't want to interfere with their view and that. So when I built my house, so I built it with the garage and then the house back from that. But I wanted to bring up something that you said accessory buildings. I had a garden shed built in the late, let's see, I think it was in the 80s or 90s. Okay, I built it with somebody, and I had a permit for that building, and I had to be 70 feet in my front yard, 70 feet from the road, they told me. Okay, so I measured it, and I had my permit. I had asked if I came in last year and asked if I could put a greenhouse on the north side of it. And they said, oh, no, you can't, because that's not, he asked me, your building, that wasn't right. Did you have a permit? I says, yes, I had a permit at that time. So see how things change, and we don't always know that, you're not up on everything. But he told me I could put it in my backyard. I would have had to put it in the middle of my yard, on the bay, my view. I said, well, I can't do that because I had trees. I said, you have to have sun for a greenhouse. So, yeah, so that's an issue. So I might come
Is
with
there
that.
anything else
But
you could-
but the reason I want to mention too, that this has happened before, and there was a little house that was only, 15 feet from the road.
It's actually where, if you go back to the, where you had the variance, the map, the new structures that you had.
There you go.
So the one, not the furthest to the right, but the second one, there was actually a house previously even further closer to the road. That was a multifamily property. Due to the flooding in the area, that got torn down. But there was a variance given now to add the garage where that structure is today. So,
So the question is.
So that garage
do
is
you-
real close.
Do you approve of what they want to do? Do you think
Yes,
this is a good
yes, I
idea?
definitely
you think they're
do.
being considered?
Because that other garage is a lot further forward, I think, than what you're going to do.
And you, sir, do you also
Mhm.
feel that?
And he was approved.
Yeah, I'd just like to.
Something you'd approve?
Yeah,
So,
I'd just
yeah.
like to add, about a year ago, I had to apply for a variance for my driveway,
Mhm.
just to the right. I know one of the concerns was, you guys didn't want that turning into a parking lot and parking cars out there, and it's not. My son moved out, and, but what they're trying to do is have a two-stall garage, and I understand now they can't get their cars in there, and that's completely fine, and, I'm the new guy in the neighborhood, so, hey, it is what it is. But I think that would help, obviously, alleviate that problem, parking their cars inside, their garbage cans, bringing their house, you know, increasing the footprint, the square footage, making it more in line with the neighbors, you know, the improvements to the outside. I just think, you know, they're kind of limited, obviously, with the width of their lot, and, yeah, definitely support their.
And they do have a narrow lot. That's the problem. They have a very narrow lot. And remember, that was Preble. And there's a lot of issues, because I used to be in Alder for a while, and I know the issues with a lot of those from Preble. They're not conforming at all anymore, you know, because, yeah, the rules that they had back then. And I've been there 54 years.
No, got it. All caught up now.
Yeah. And I've been there 54 years, lived there, so, yes, I know all the things that have gone on, and there are changes. And I can understand some of them, but right now, we're like 200 feet from the road. So, I mean, the issue is, as long as the neighbors don't mind, it's, to me, I think it's okay. You know, because they have the room. I could see if they were coming really close to the road, that might be an issue, but it's not.
Any other questions from board members?
I have 2 other people in it.
Do you have other folks here to testify as well?
That's our elder sitting back there.
Okay.
He came.
All right. All right, well, then we're going to go into deliberations. Thank you very much.
I can take a run at it if you want.
Please, I've been talking too much tonight.
No worries. So, excuse me, my eyes are really red today. So let's start with preservation of intent. Variance would not be consistent with spirit, purpose, and intent of the regulations. So in terms of that, I think that granting this variance would be within the spirit of the ordinance, simply because you know, the way things are on East Shore Drive, this board pretty much runs on East Shore Drive and Astor Park and a couple other places, because you know the lots are uneven, were put up years and years ago, well before code, and there also tends to be more of a, for lack of a better term, kind of a way to delineate the lots, if you know what I'm saying. I mean, nobody really looks down the lot. This is essentially a country road, not a city block.
Yes.
So I think this is within the spirit of intent. Exceptional circumstances, I think that the narrowness of the lot, the original uses of the lot, and what you're trying to do with it, the way it is set is an exceptional circumstance to me. Preservation of property rights, you really don't have much places you can go. You know, the lot's narrow. There's not a lot that can be done there, and I think in order to, I think it's not unreasonable for you to ask for a two-stall garage on a property like that. And it's road facing, so I think that also goes to absence of detriment, right? It's actually going to improve the, at least from the road look, not to say that your place isn't lovely already, but, you know, you did bring it up, so, you know. Will there be any, you know, detriment to the adjacent properties? And I don't think so, and we've had testimony saying that as well. I think that in this particular case, this is being done with thoughtfulness, and that's come across at least to me. And then hardship, complying with the municipal code. I think in this particular case, it really isn't self-imposed, nor is it on economic grounds. And complying with the municipal code basically means not doing the project at all, which then conflicts with preservation of property rights. And in that balance, I would come forward with property rights. So that's how I would approve this. That's my rationale. All the board members would like to add to that.
I mean, the additional thought I had, and I heard a little bit in staff presentation, is that, you know, the addition here is still inside of the average of the accessory buildings, which are, you know, when we're looking at this whole picture, we're looking at, you know, where's your eye draw? And, you know, we're not sticking this thing out way towards the street, you know, outside of even where those front end accessory structures are. So I think it's, you know, it's within the eye line of the neighborhood. And I would also say, you know, putting more more property out towards the bay, with, water issues and things there. It's probably a better idea to build it more towards the street than towards the bay. Never mind the good neighbor aspects of this proposal. So that's just my initial thoughts.
Oh, that sounds good.
It sounds like we're perhaps at the stage where someone might be able to make a motion, if one might be coming.
Sure, I will motion to approve the variance.
I'll second.
As requested.
We have a motion, we have a second. Any further discussion? Hearing none, all in favor?
Aye.
Aye. All opposed? You folks have your variance.
Thank you.
Work with John and all the other powers that be to square things away.
Thank you so
much.
Thanks for the recommendation, John.
Yes, thank you.
And thanks again for your patience tonight.
Yeah, absolutely.
You picked a bad night to come on down.
Yes.
Long night. Moving on to the agenda here, our next meeting is Monday, May 18th, 2026. And finally, I would entertain a motion to adjourn.
So motion.
And I'll second.
We have a motion, we have a second. Any further discussion? Hearing none. In favor of our ailing board chair, all in favor, say bye.
Aye.
Bye.
That's all.